colleague joined from the other side? I mean, the Claimants Council.
No, I've not seen him. I've not seen him.
Okay, so we should wait for them for a while. They
escort places, my lord.
Okay.
Okay, so I wait for you to take the other matter.
No, even in the other matter, sorry, in the other matter, the other council, the Claimants Council is not yet in court, but so let's wait for them for a while.
Okay, my lord. Escort places.
I can see Stella and Vincent.
Yes, my lord.
Yes, Vincent, you're representing who?
I'm representing the complainant.
In which case? In the case of Jato? Joseph Jato?
In the case of Jato, yes.
Okay.
Yes, my lord.
Okay, what about Stella? Stella Oba?
I don't know.
Yes, no, she can hear me if she is with us. Okay, since Vincent is here, can we take the Yes, Mr. Vincent?
Yes, my lord.
Yes, you can hear me?
Yes, my lord.
Okay,
I can also hear you, my lord.
Okay, so can we go on with your case?
Yes, my lord.
Okay, Vincent and
yes, my lord. Before you is a motion.
No, announce it.
Sorry, my lord. My name is VT Totsu. VT Totsu. For the VT nations. Totsu is from the law of Tots. Tortsugh.
VT
Totsu. Tortsugh.
TS.
From Tots, then you add UGH.
Yes.
For the complainant, my lord.
Yes. Yes.
My lord, Mrs. M.M. Ikulono. M.M. are the initials.
Yes.
Ikulono is spelled IKWULO.
Yes.
NO. Ikulono. Yes, my
Yes.
Lord. DDCL.
Okay,
DCL. My Lord, I hold the brief of P.O. Agbese, the DCL, Benue State Ministry of Justice, for all the defendants. Much obliged.
Okay. Thank you.
Much obliged, my Lord.
Thank you.
Yes, my
Much
Lord.
obliged, my Lord.
Yes.
My Lord, before you is a motion or notice
Yes.
brought pursuant to the inherent jurisdiction of this honorable court.
Okay.
Praying, my Lord, for an order granting the leave to the applicants to apply for extension of time within which to file the claimant's final written address out of time.
Okay, just sorry, Mr. Vincent, please hold on.
Yes, my Lord.
Yes, Mr. Vincent, you are.
Yes, my Lord, I said we have a motion
The matter
that
is for adoption
adoption
As
of
court pleases.
of final written addresses.
written addresses. But we have
A motion
a motion
praying this honorable court
mm,
for extension of time within which to file written addresses, final written addresses.
for final Kulolono, any objection?
No, no objection, my Lord. We've been served. We do not intend to oppose the motion.
Okay.
Not obliged.
Yes, Mr. Vincent, can you move in terms?
My Lord, I move the motion dated the 18th day of March. No, the motion is third day, sorry, my Lord. Third
And
day of
file on
March and filed on the 18th day of March, 2021. I move same in terms of the motion paper, my
3rd of
Lord.
March
2021, my Lord.
yes, but filed
Filed on the 18th of March,
on the 18th March 2021.
2021. Yes, my Lord.
Yes. So application for extension of time to file the claimant's final written address out of time, dated 3rd March 2021, but filed on the 18th March 2021 is granted as spread.
As court places. Much obliged,
Yes.
my lord.
Did this year?
As court pleases. Yes, my lord. My lord, we filed our final written address on the 19th day of November 2020. And subject to court convenience, we're ready on the 19th, my lord.
Yes, November 2020.
20,
Yes.
yes, my lord. And subject to
Yes.
court convenience, we are ready to proceed.
Okay. Mr. Vincent, you are ready?
Yes, my lord, we have been served. We have been served. We are ready, my lord.
Okay, DDC, can you go on?
As court pleases. My lord, the final written address of the defendants
Yes.
filed on the 19th of November 2020
Yes.
has a loan issue,
Okay.
which is whether from the evidence before the court, the claimant has proved his case as required by law
Yes.
to be entitled to the relief sought.
Yes.
My lord, our argument is contained in paragraphs 3.0
Yes.
to 4.0, my lord.
Yes.
Excuse me. We wish to humbly adopt our submissions
Okay.
as contained in the address
Okay.
in urging this honorable court to dismiss the plaintiff's claim at the complainant's claim in its entirety. For lacking in merit. And we so urge the court.
Okay. Thank you.
Much obliged, my lord.
Mhm. Yes, Mr. Vincent.
Yes, my lord. Having been served with the defendant's final written address, that's the 1st to 5th defendant's final address, we filed the claimant's final address on the 18th day of March 2021.
Claimant's final
Written address
was filed
on the 18th day of March 2021.
Yes.
Which were granted leave today to move same.
Yes.
Our main issue, we also have a loan issue,
Okay.
which is whether the claimant has proved his case as required by law. to entitle us to the relief sought. Our legal arguments are contained in paragraphs 3.0
Yes.
down to 4.01. 4.1.
Yes.
And we urge, my Lord, to grant all the reliefs sought by the we urge, my Lord, to want to adopt the liturgy address. I urge, my Lord, to grant all the reliefs prayed by the complainant.
Yes.
I appreciate, my Lord.
Thank you, Mr. Vincent.
Yes.
Is that
Thank
yet
you, my
okay
Lord.
for 30th of this month for judgment? That will be on Thursday by 2 p.m. Is it okay for you?
Okay. Via the
DDCL.
same Zoom. Yes.
Ascot,
It's okay
please.
with
Yes,
me.
yes, yes. It's via Zoom.
Yes, my lord. We will
Okay.
take
Ascot places, my Lord.
Okay.
Yes, much obliged.
Thank you.
Thank you, my Lord.
Thank you. So the case is until the 30th of September 2021 for judgment.
Ascot, please.
Ascot places.
Thank you. Okay.
Much,
Thank you.
much obliged, my Lord. Yes.
Thank you.
My lord, may I have your permission to pull out?
Granted. My regards to the council and the ministry.
Ascot, please. Much obliged, my lord. Yes,
Thank
sir.
you.
Yes, sir.
Okoro have joined.
Yes, Mr. Timothy.
Very well, my lord.
Okay, I can see Mr.
Mr. Okori has joined
yeah.
us. I can cite his face.
Okay.
Okori.
Okay. Yes, Mr. Is it Okori? You muted yourself. Mr. Okori, you muted yourself. Dr. A.M. Okori, you muted yourself.
Try. Okay.
He has muted himself.
Okay, I can't hear him too.
Yes, because he has muted himself.
Okay. Try and unmute yourself.
Yes.
Doctor.
Dr. A.M. Okori, are you with us? Can you hear me? Okay, I think he's reconnected. Huh?
It may be because of poor network.
Yes, but I think he's trying to reconnect.
That's costly.
Mr. Okori.
My lord.
Yes, are you with us? Good afternoon.
Yes, I am.
So your appearance.
With profound humility, my lord.
Is your client in court?
Yes, he is. I saw him.
Okay, so claimant in court, claimant present.
Claimant, yes, my lord.
Okay. Yes. Yes.
With profound humility, my lord.
Yes.
Dr. A.M. Okori.
Dr. A.M.
Okori. O-K-W-O-R-I. Yes, my lord.
Yeah. For
the claimant.
Yes, Mr. Timo. Are you alone, Mr. Okori?
Yes, for the purpose of this sitting, I'm alone.
Okay.
Yes, sir.
Mr. Timothy.
Yes, with proper humility.
Yes.
I am Timothy. I appear for the defendant.
Okay.
Good afternoon, learned colleague from Jos.
Thank you, Mr. Dim.
Yes, sir. I'm putting the book too.
Yes, Mr. Timothy.
Very well, my lord. Yes, my lord. The matter comes up today for adoption of final written addresses.
Yes. And you are ready. And you are ready.
Yes, we are ready.
Mr. Okori, you're also ready.
My lord, I'm ready, sir.
Okay. Yes, Mr. Dim.
Yes, my lord, the defendant's final written address is dated and filed 13th day of February 2020.
Okay, defendants. Final written address is dated
On filed 13th February 2020. It's filed within time.
okay, is dated and filed?
13th February, 1-3.
Yes, dated and filed the
13th.
same date.
Yes, my lord. Dated and filed 13th February 2020.
Okay. Yes.
My lord, on receipt of the claimant's address, we filed our
Address.
reply.
Okay.
My lord, it is dated 2nd September 2020, but filed on the 15th of September 2020.
Okay.
It is also filed within time. My lord, it was filed on the 15th only because of the rule of the court that because of the COVID protocol, we have to
Yes,
drop our
yes.
box and wait for
Yes.
the number of things to pass. Yes, my lord.
Yes.
In urging my noble lords to dismiss this action, we adopt both our main and
Okay.
reply address.
Okay.
Yes, sir. We adopt both our main and reply address, urging my noble lord to dismiss this action. My lord, we have stated clearly in our address that the contract of employment has been frustrated. There is no university, Otukpo campus of Uniagri to which the claimant can be restored to. In fact, my lord, as we speak, the federal government has reestablished the university again.
Okay.
Full-fledged university. So if the claimant is now brought in, where will he go and work? There's no way.
The federal government has now established the college as
That university now as a full-fledged medical university with its principal office.
When was that?
That was last year.
Are you re-employing the claimant?
No, my lord.
Are you
That
re-absorbing
is the university of its own. It
okay,
is no
it's
longer
university now. It's university.
Of its own.
Okay. But you said when was the contract or employment frustrated?
That was in the year 20 when he was terminated in the year 20, I think 2014 or 2018, 2019.
No. He was terminated in sometimes in 2018.
Yes, my lord. That was when the NUC said we should no longer run that program.
No, the letter from the NUC was in 2016.
Yes, my lord.
It was in 2016 that the NUC sent a letter that the university or the college university doesn't have any mandate to
run that.
Yes, and that was in 2016.
No, my lord. That was
there is this exhibit PRO. I think PRO something, PRO 7.
Scott, please. Yes, my lord. My lord, yes, my lord.
It's PRO 7. The university said, this is what the letter said. I'm directed to inform you that the commission is constrained to process further application for the establishment of College of Health Sciences at this request outside the mandate of the university. University is therefore requested to concentrate on a program that have direct bearing on the essence of University of Agriculture.
Yes,
the university therefore should not enroll students into the proposed college without appropriate approval from the commission. This letter was written on the 18th of November 2016. 2016, yes. So,
Yes,
so this is the letter that was the. It is the letter that formed the
that was the basis
informed the hello.
Yes, that was the letter, the basis for our terminating.
Yes, okay.
The employment of the claimant because his services
the basis of termination. But you didn't terminate until sometimes in 2018.
Yes, my lord, because administrative purposes mean that administrative structures have to be followed. As you say, the university senate, the university council sat deliberated over the matter. It was after that the decision to terminate was taken.
But Mr. Timothy, isn't it, as you have conversed in your final written address, the employment letter said that either party can give 6 months notice.
Yes, my lord.
She or he wants to terminate. So from that time that the NUC sent that letter to you,
yes, my lord,
in 2016.
Yes, my lord.
Why didn't you just invoke the provisions of the appointment letter and give the claimant 6 month notice instead of waiting till 2018 to terminate the appointment?
Yes, my lord. That is why I said even if the appointment was terminated wrongly, that is without notice. It's only entitled to 6 months salary in lieu of notice. If it was not 6 months notice, it's entitled to that. That is the damages the law says is entitled to. 6 months in lieu of notice, not to bring him back. Because if you bring him back, where will he go and work? Where will he go?
So you admit that he's entitled to 6 months salary of
salary in lieu. So if he was not given that salary, it's his entitlement. He's entitled to that. That is the damage recoverable, and nothing else.
What about the cost of filing and cost of engaging a legal practitioner to represent him in court?
I know that solicitors' fees cannot be basis of any action. They are not claimable. You can't claim solicitor's fee. That is the law in Nigeria. It is right.
Then what about the general damages? Isn't he entitled to general damages? The claimant.
Damages is what we say, that 6 months salary in lieu of. That is what the law says is entitled to.
Okay.
That is what the law in our written address.
Okay, the 6 month salary will be based on which of the pay slips, because there are 3 pay slips. There's the one you're paying him 1.149, after deductions, and there's the one you are paying him 936,000 naira. Because the claimant was alleging that he reduced his salary sometimes in August, July.
The last point of pay, that is the one. Because even that reduced salary was based on directives from the Ministry of Education. Say this is what people of this category.
But you didn't tender that circular from the Ministry of Education or what? You didn't tender that circular.
Well, my lord, time has passed, so I cannot really look at what is what about. My lord, what is entitled to?
You mentioned you stated in your final written address that the reason why the salary was reduced was because any medical doctors are not entitled to some certain allowances.
Yeah.
Right, but you didn't tender that circular. In any event, yes.
Well,
so
my lord, the
yes, Mr.
The letter of employment specified what was to be paid.
The letter of employment said what?
Specified what allowances that were due to him, the salary. The letter of employment specified that.
It said what? What did this say?
My Lord, we need to look at that is exhibit
2.
since we
PRO2.
attended
PRO2.
PRO2. Yes, my Lord.
Mm.
PRO2.
Did it state any salary?
My Lord, the allowances there are based on what is obtainable in similar position. I think that is what I'm trying to look at the claim, because he tendered those documents in the court.
He tendered some pay slips, 3 pay slips, showing what you've been paying him. In some instances, you are paying him 1.1, and you reduce it to 300, 930 something thousand naira. So I want to know the reason for the reduction.
My Lord,
Yes.
we stated in our defense that some of the allowances the claimant was paid, it was not due for them, and that was why he was brought
Yes,
back.
but Mr. Timothy, how will be able to justify that he wasn't entitled to the salaries you are paying him in the past?
The circular from the ministry.
And why the circular? Is it before me?
Well, my Lord, it's for my Lord to decide.
Okay, it's okay.
I need to begin
okay.
to join it, my Lord, but we have placed our case before my Lord.
Okay.
So if the claimant brought 3 separate pay slips, I don't know which one he wants to act on. So it is for him to prove what is due. It's not for us to justify it for him. He brought 3. Yes, my Lord. So my Lord, I urge that this matter be dismissed. But the contract is for. Yes, my Lord. And the contract is for. May it please the court, my Lord.
Thank you.
Thank you, sir.
Thank you. Yes, Mr. Dr.
Okori.
Yes.
Yes, my Lord. For the claimants, the final written address was filed on the 13th day of March 2020.
Okay. Claimants final written
address
was filed
on 13th March 2020.
Yes.
And dated on the same date.
Okay.
Also dated
was dated on
March 2020.
Was dated and filed. Yes.
On 13th March 2020.
Yes.
I most humbly adopt the said written address.
Okay.
And urge my Lord to consider the 3 issues distilled for determination.
Yes.
And enter judgment in favor of the claimant.
Yes.
In respect of either the main claim or the alternative relief claim.
Okay.
Yes.
Alternative. Yes. Yes, I can hear you.
Yes.
I can hear you.
My submission is predicated. Yes, my submission is predicated on the fact that if reinstatement, if my Lord finds that the claimant cannot be reinstated, the claimant is entitled to be paid all that is due to him for a tenure of 5 years, as canvassed in the address.
But the appointment letter says either party can terminate the appointment by giving 6 month notice or 6 months salary leave of notice. Well, and with that, can the court still reinstate or give the claimant the full salaries for the for his tenure? That's
yes,
for 5.
yes, my lord. Yes.
Okay.
From the argument we canvassed in our written address, this is an employment that is done with statutory flavor. And we had canvassed based on the statutes that established the university and the conditions of service. There is nowhere in that condition of service or the act that gives the defendant the power to terminate the employment of the claimant summarily.
But the termination was not based on any reasons.
Yes, sir. That's our point. Based on the condition of service, if you are going to terminate a staff whose contract is tenure, you have, based on statutory flavor, you have a responsibility to give him fair hearing and tell him this is the reason why we are terminating you.
But the termination was not based on any misconduct or infraction, so that the claimant would be given any fair hearing. So those, for the purposes that his services were no longer required.
Yes,
the defendant didn't terminate on the basis of any misconduct. And what
yes,
fair
Lord,
hearing I say what
yes,
fair hearing you expect the defendant to give the claimant? If they're just terminating the appointment without saying anything, without saying that this termination was based on any misconduct on the part of the claimant, do you expect any fair hearing to be given to the claimant?
Yes, my lord, based on their own statute, because you see, this is employment that is regulated by law.
Yes, but
there's nowhere. Yes, sir, my lord. The point I'm making, my lord, is that nowhere in the law, even in the data that says that, look, you terminate him without giving him any reasons. There's nowhere. Even the issue of frustration that was brought in.
But the appointment letter
they came to say that.
The appointment letter says somebody can be terminated by giving, by giving him 6 months notice or 6 months salary leave of notice. The appointment letter says that.
Yes.
So can the defendant now terminate the claimant by giving him 6 months notice or 6 months salary leave of notice? Can they do that?
Yes, my lord. My worry actually is that the letter of in the letter of appointment in the letter of appointment order reference, they say that that letter of appointment is made subject to the status, the conditions of service, and all the regulations guiding the defendant.
Yes, but it has expressly stated how the appointment will be terminated.
Yes, my lord.
Yes, it has expressly said that. I mean, the letter of appointment.
Yes,
in any case, in an alternative claim. Yes, sir. You've stated 1.260 or 1.206 as the monthly salary of the claimant. But from the slips, from the pay slips that you've tendered, it's like that 1.206 was before deduction. After deduction, it is 1.149.
Yes, sir.
Because 1.149 is the net pay.
Yes, sir.
The 1.206 you've stated in your alternative claim was the gross. Because this thing before deduction.
Yes, sir.
Mm-hmm. And in your reliefs, so the even if the claimant is entitled to 6 months notice, it will be that 1.1, not 1.2. That also?
Yes, yes, sir.
Okay. And the another thing is that in your reliefs,
Yes, my
you
lord.
ask for that the in your relief number, I think 4.
Yes, my lord.
It says that a declaration that the monthly deductions from the claimant's monthly salaries to differ from July 2018 without the claimant's consent is arbitrary, unjustifiable, wrongful, and illegal.
Yes, sir.
But you have not asked for any order to pay you, the deductions. You've only asked for a declaration to
Yes, sir. If
that the deduction is illegal.
yes, sir. My lord, those
A mere declaration. You only asked for a mere declaration that the deductions were
yes, sir,
illegal.
my lord, if my lord looks at
But
relief
you
number
have not
6.
asked for any order for refund.
If my lord looks at prayer 6, my lord, relief number 6.
Yes.
We're asking that the court should make an order to pay him all his the claimant all
the salaries, allowance, and other entitlement due to the claimant as at 18th of 18. That is this is a post termination allowances and benefits.
Yes, sir.
Yes, but in the case of the deductions, you didn't ask for any specific order to
for the deductions.
Yes.
Okay.
Yes.
My lord, if I may just submit quickly on that.
Yes.
If the court finds that the claimant has made his case, I'll urge the courts as a court of justice to invoke the inherent powers of the court.
But the
grant
court,
that relief.
it's not Father Christmas. It's not a final.
Yes, my lord.
Anyway.
Well, in any case, my lord,
yes.
The claim of the claimant, the point we are making actually is that if I now looks at relief, the alternative relief 9A.
Yes.
Our point actually is that from the arguments that we have canvassed in our final written address, the frustrating circumstances which the defendants have alleged were only disclosed after we had made the points that no reasons were given for his appointment.
Okay.
Even, after we had canvassed that they couldn't have terminated him without giving any reasons based on the conditions of service and the status establishing the university. So now, if there was a frustrating circumstances as claimed by them, that was not even proved before the court as far as we are concerned, because the claim of the claimant from what he has proved was that exhibit PRO 8, which they were relying on to say they had no mandate, it showed clearly that even the claimant had taken steps to ensure that the college should take up, but they didn't do what was needful. So why would they now punish look, when you were making address, I didn't interject. Allow me to make my case. When you were speaking, I didn't interject. With due respect to you.
The motive for the defendant terminating can never be a basis for your action. It can never be. The law is clear.
But you gave him the letter of employment. Why didn't you say that? You gave him the letter of employment, and you made the letter of employment subject to the university status and the conditions of service.
Very well, my lord.
Why didn't you say that?
Mr. Timothy. Mr. Timothy, you said that a frustrating event.
Yes, my lord.
That was why you terminated the claimant.
Yes, my lord.
Then in the letter of termination, you didn't mention that. You didn't mention that you are terminating him because there was a frustrating event.
My lord, once employment is lawfully terminated, the motive has never been a factor. The
Not
motive.
for a statutory employment. Not for a statutory employment. That's why you missed it. This is not an ordinary employment. This is a statutory employment. Employment with statutory flavor.
That is why it says you can terminate giving each other 6 months notice. And we did that.
You gave him the notice?
We
No,
terminated.
no notice was given. All of this you are saying, with due respect, sir, all of what Mr. Timothy Dean is canvassing are facts now that came after the event. Even what he was saying, the university was established, a current university was established after the claimant had made his case in court. It's not even before the court. Of course, the court can take judicial notice of that. It's not before the court.
What is not before
with due respect, sir?
Okay, it's okay.
The fact that a full-fledged university has been established is not before the court.
My lord, the court can take judicial.
You can't prejudice the mind of the court without consideration. Yes, my lord.
Notice. So if you bring this man back to work, where will he go and work? The court should take judicial happenings in the country.
Mr. Corey.
Yes, my lord.
What is that not for the court?
My lord, my lord.
I say, what is that thing?
My lord, my lord, let me close my address.
Okay.
Subject to whatever questions my lord may ask me. If my lord looks at the relief, because if we have finished this case long ago, what he say now, we don't have a reason. If my lord looks at our relief, particularly relief 9A.
Yes.
Let me just go there quickly. My lord will find that the claim that we have made is just up to the period 2nd February 2020.
That's when the
that is when his 5 years will have elapsed. So even at this point, reinstatement will not be possible. If we assuming we have finished this case in 2020, much earlier in 2020, what the point my learned friend is canvassing now, will he arise? He won't arise. It's not because of the situation of COVID. So if my lord looks at that reading, it just up to from 2018, September 2018, 18 September 2018, so 25 February 2020, and the 5 years were elapsed. Then you why they gave him that 5 years and made it subject to their law. So why would they punish him? Because within that time, as canvassed in our, he took a leave, sabbatical leave for 5 years to come and work with them. So if there's a frustrating circumstances, he will be punished for that. If they knew there was that frustrating circumstances and they wanted him to leave, as my lord has rightly observed, why didn't they give him that notice? They waited for 2 years. And then you now come and say, no, don't bring in malice. This is a court of justice. It was clearly like a sledgehammer that was used on the claimant for no fault of his.
My lord, with all respect.
So this is it.
The point. Mr. Timothy. Yes, Mr. Okori, I can hear you.
Yes, my lord, with due respect, sir. My submission is that if the honorable court finds that the claimant is no longer entitled to reinstatement, which the case clearly shows, he's no longer entitled to reinstatement, the alternative relief should be granted and will go away. And then, my lord, even at that, in all fairness, if the letter of employment says give in 6 months, why were you in a hurry to terminate him summarily? And then you come in one breath, you say dismiss him. In another breath, you say he's entitled to 6 months. What is the justice there? If the man is entitled to 6 months, you come and say, oh, he's entitled to 6 months. You say dismiss the claim, showing that he has no claim at all. And then you now turn around and say, well, we didn't give him 6 months. The entire circumstances shows that the claimants were out to just get rid of the defendants were out to get rid of the claimants.
My Lord, the Idigbe is going to send him the matter
Okay.
So, my Lord, in conclusion, my
Yes,
Lord,
Mr. Okori.
in
Yes.
conclusion, I urge the Lord
Yes.
to consider the letter of employment and the status establishing the university and the conditions of service subject with the letter was given, and to grant the relief claimed by the claimant in the interest of justice.
But if Mr. Okori, if the law establishing the defendant is saying, is silent about the termination of the appointment of the claimant, but the appointment letter is expressly saying the mode of the termination, which one will you pick? The law establishing the defendant is silent about the issue of termination, not on grounds of misconduct, but the letter appointing the claimant expressly says the mode of the termination.
Yes, sir. My Lord, I wouldn't make this argument I'm making very clearly. Yes. I will make this argument I'm making about the conditions of service, about the university law. If the same letter had not made the reference to it, then the intention of the legislature would have been very clear. And that intention, we can't read any meaning into it which is not there. If the intention says, look, either party can terminate, giving 6 months notice to themselves, that is very clear. Nobody can move beyond that point. We stop there. 6 months notice is given, issue closed. Even if 6 months notice is not given, it is taken for granted that, look, the law implies that 6 months notice should have been given. So the court can read that into that. But in a situation where the same law, in the same breath, says that, look, even this issue of 6 months is subject to the status. And then you go to the status, the law establishing the university and the condition of service, and it tells you what conditions you should pass through. To me, that's a problem. If the legislature has simply said, give in 6 months notice, simplicity, that will have answered the question for me. But the legislature has manifested an intention to go beyond the letter of employment, because the employment letter is not looked at in isolation. It's looked at also subject to other conditions that binds the employment.
But Mr. Okori, what about if the parties have agreed to exclude that legislation by saying expressly that this should be the mode of termination of the appointment? If they try to exclude that legislation by sitting expressly in their agreement that this should be the mode of the termination, what do you say about that?
My Lord,
well, if they agree to exclude it, certainly I will not argue that. But my point is that they have not said they are excluding it. They are the ones that brought it. If they didn't want it to be included, they would have left it. Because you see, because this is Nigeria, and we know how things are done in Nigeria. Somebody is brought in for a tenure, and then suddenly midstream you say, we don't want to see your face, you can go. This is the kind of thing that letter of employment seeks to address.
What happens in Nigeria? My lady friend is going to sentiments rather than addressing the issue. If assuming my lord,
addressing the issue of the letter,
6 months notice, decide that he was going to leave service within 6 months, can we force him to remain in our employment? If on his own he decided to leave, giving us 6 months, can we force him to remain in our employment? The answer is no.
Okay.
The answer is no. Obviously, assuming he gave us 6 months, that he no longer wants our employment.
Okay, it's okay. It's okay. I've heard all of you. Yes. So let me adjust. I've heard all of you. Let me adjust for judgment.
Yes, please.
If my Lord will give us a date for this matter has been on for quite some time. At least so that parties will know their rights and their faith.
Yes. Let me see. Tomorrow will be what? Tomorrow will be
28.
Oh, okay. Let's make it on 30th, on Thursday. So that it will be held alongside the other matter. Is 30th okay on the same time? Same time, that's 2 p.m.
Very well, my
Yes,
Lord.
And Mr.
But that's-
Timothy, Mr.
that's-
Okori, is okay?
Faith.
Yes, my Lord.
Okay.
It's okay, my Lord.
Okay. So, case is adjourned to the 30th September 2021 at 2 p.m. for judgment.
As complices.
My Lord, we appreciate my Lord for the indulgence.
Thank
We're
you.
grateful, my Lord.
Dr.
Sorry,
Aaron Okoro.
the judgment couldn't be, the adoption and judgment couldn't be done because of the COVID, my transfer to Lagos and all that. But we thank God that we are now going to see the end of the case by Thursday.
My Lord.
Yeah.
We appreciate my Lord.
Yes, my Lord. We're grateful, sir.
Thank you. So, gentlemen, I think that's all for
We're
today.
grateful.
Yes,
Thank you, my
Mr.
Lord.
Okori and Timothy. I wish you all the best.
Thank
I
you,
wish you a
sir.
very good afternoon.
Same to you, my Lord.
Yes, thank
Till
you.
on- Thank you,
Okay.
sir.
Okay, bye
Thank you,
bye.
my Lord. Yes.
My Lord.
Mm-hmm.